Good afternoon, everybody. This is Omar Serrato with the Tilted Lawyer podcast. Of course, Mike wouldn't be tightened up. It's tightened up now. Anyway, so the judge, let me unecho myself. I think that's better. I think that's better. Let's see. Just want to make sure I can't hear myself. Did y'all hear me okay? Can you guys hear me just fine? Want to make sure before I start going in on rant, everything is. Anyway, it appears to be up. All right, folks. It's the same link. All right. Lauren 90 might be joining us, but look, I did a whole the other night, a 55-page reading courtesy of Lauren 90, who obtained the transcript for herself of the March 6th hearing where they were arguing the issues about whether or not they were going to expand on the court's model protective order. They're asking for attorneys' eyes only provisions, and they had that whole thing. Well, the judge came out, and I think Lauren actually broke it this morning, that the judge made his findings, and it was kind of a win and a loss. He gave a little, he took a little. He issued AEO designations for some things, but not for everything. And so the issues before the court were essentially, and by the way, I'm going to break this down point for point about what essentially is in the order, what I think about it, because he said some things that are important. Namely, he went on about how he is not pleased how this case is being litigated in the media. And he had stern, I don't want to call them admonitions, but he was like a concerned dad who was grossly disappointed at the way that the children have been acting. And so he spent some time in his 22-page memorandum chastising both sides of the V. Both sides of the V. And we're going to get into some of that. I'm going to read page for page the 22-page memorandum that goes into his it's lightning and thunder outside. I like it. Hold on, folks. I apologize if I'm rushing a little bit. I just got out of court, so I'm kind of amped and trying to get things situated. I got a limited time where I could do this, and so I'm doing it now. As I stir my tea. So the issues before the court was, as you recall, Lively's team was asking for a strict protective order. But it was overbroad in that they wanted everything to be attorney eyes only provisions. And they wanted Friedman and his legal team to look, if there's something you don't think that should be attorney's eyes only, then we could meet and confer and have a hearing on it. And then Friedman was like, that's bullshit. Why should I have to do that? You guys should have to do that. And then the judges hearing both sides. They were seeking any information that could be obtained in discovery on the premise that, well, they've already leaked a bunch of stuff and we don't want them to leak stuff to the press, essentially accusing Friedman and his office of purposeful leaks. Oh, Lauren's going to come in at 15. Hey, Lauren, if you can't get a hold of me for some reason, let people in the comments know. My reception in the office sucks. So if you try to text me, it may or may not work out. What's up, pal of a girl and Winks and Sarah Dawn? I learned about what BLV was or whatever that. She used some kind of an acronym. I think it's like unique to where she lives. I've never heard it before. And Anthony Bunsey. Oh yeah, there is a full red moon that's going to be out tonight for your viewing pleasure. The last blood red moon that I can remember, I think would have been like 2015. I watched it with my daughter. We went outside, we took pictures and stuff. Well, not very good ones. It was off my cell phone, but hey, if you get the opportunity and you're in North America, be on the lookout for it. So anyway, back to this. This is the court's decision. The court partially granted Lively's request. He allowed AEO designation for specific types of documents, but limited its use to prevent abuse. So what can be designated as AEO? And this is what he said. He said, basically, trade secrets, confidential business info, marketing plans, client lists, confidential projects unrelated to It Ends With Us, stuff that protects stuff from competitors from misusing business sensitive materials. That was protected. Fair. And as you recall, when I was reading the transcript, he was particularly interested in that category of documents. Security measures, any private security details of Lively, Reynolds, and others are going to be AEO protected. Fine. To prevent the exposure of protection strategies, I guess. No big deal. I mean, Friedman is basically said, I don't give a shit about their security protective measures. Obviously, medical information, physical and mental health records. Some of you guys were asking, what kind of medical record? What are they trying to hide? I'd imagine what they're trying to hide is psychological records of possible diagnoses. You don't want that stuff to get out. I mean, how many of you guys have been to the doctors and been diagnosed with depression? Whenever somebody is ordered into a psych eval, like the most common diagnosis is major depressive disorder, among other things. And, you don't want people prying into your mental health issues. And so that's obvious. It's already protected, but now it's under an AEO protection order. Any highly personal or intimate information, third parties, non-relevant info on Blake and Justin, text messages, emails, recordings, not central to the case, but that might be embarrassing or invasive. Like, for example, nude photographs that you might send to some unsuspecting single person. By unsuspecting, I'm specifically talking about women. How many women in the chat have received unsuspectingly random dick pics in their text messages because they're messing around on Tinder or something? I don't know, but it's a thing. Any third-party data, private conversations with unrelated celebrities. Here's what cannot be designated as attorney's eyes only. Marketing and business strategy for It Ends With Us, because the lawsuit revolves around the film's production. Business discussions related to it are not confidential. Any evidence directly related to the harassment and defamation claims themselves. Anything proving Lively's allegations of retaliation or Baldoni's counterclaims, they have to be accessible by both parties, and I'd imagine that that's probably because of due process considerations. Anything that's already public is not going to be AEO designated. This is the judge's rationale. He recognized that there is a high risk of leaks in a lawsuit where both sides of the V have been accused of leaking information to the press for nefarious purposes. Both sides have accused each other of leaking sensitive materials to control the media narrative. There are some individuals in the case that work in PR and media, and leaks are pretty hard to trace. He wanted to balance that, however. He wanted to balance the need for access to those materials versus privacy, because after all, this is a public, high-profile case. I think you heard him say that, look, if you sue a high-profile individual, you're going to have a lot of people interested in it. And good luck keeping it under wraps. And I'm not inclined to just issue a blanket AEO orders, is what he said. What's up, Bruce? I see Bruce in the chat. Omar, BYS, it's just pronounced like buys? Buys? The hell does that mean? So in the context where you use it, where did you use it? You said, what's up, buys? Oh, what are you at, buys? I don't get it. I'm lost, Sarah. I'm completely lost. We'll talk about that later. Well, anyway, buys. I don't get it. The judge is trying to balance the need to public access and the need for privacy. The need for privacy being that there's safety considerations, business, trade secrets, whatever. Lively's side cannot use attorney's eyes only protections to block Justin from his due process rights that were constitutionally granted to defend himself. There's some categories, security, medical records, third-party info that we previously discussed that would fall under that category. But to the extent that the information is related to a direct allegation against Justin Baldoni, bullshit. Nope, that's not AEO protected. Fuck off with all of that. You can't just say all these allegations and then he's asking you for the evidence and then, oh, well, your attorney can't show that to the accused. That's nonsense. The court does retain discretion in this order if either side abuses the attorney eyes only designation. The other party can challenge it in court, but that was also inherent in the old order as well. So the final ruling, it modified a protective order with an AEO provision limited to specific categories. If a party wants to restrict additional information, they have to file a motion for court approval, and that's just how they're going to do it. Here are some key provisions of the protective order. They ferreted out definitions of confidential and AEO information. For example, confidential will include financial, business, personal information that, if disclosed, will harm a party or a third party. Attorney's eyes only is reserved for trade secrets, security measures, medical records, and highly personal information. What it is not reserved for is evidence that's tied directly to Blake that might be part and parcel of a direct allegation that was made against her. So largely what's being protected is third parties, but the parties, fuck off, you're fair game. They're not going to get much protected as a result of that. And so that's kind of the give and take. The judge was sympathetic to people that might be dragged into this lawsuit involuntarily, but you guys are suing each other. He has a right to face his accusers. He has a right to confront your witnesses. He has a right to examine the evidence you have against him. It was constitutionally granted. It's been a thing for nearly 300 years now, and we're not going to change it on account of you, is basically what the judge is saying. Confidential materials can be shared with the parties, with attorneys, and specific witnesses. In other words, just because you might be a witness in the case, you're not allowed to view confidential materials, but that's just kind of the case anyway. As for attorneys' eyes only materials, those can only be viewed by attorneys, experts, and court officials. So what did Lively really win here? Well, not a whole lot, because the only things that fall under that specific provision, trade secrets, security measures that Friedman already said he doesn't give a shit about. Trade secrets, fine, I guess, to the extent that they are trade secrets. I guess that would be probably the highest grounds for some kind of contentious motion down the road. Medical records, obviously, but we already know that. We're all attorneys. Highly personal information. I don't think anybody's trying to leak the addresses of prospective witnesses. I don't even do that in my private cases for non-celebrity. But attorneys understand that, and so it's not really an issue. So what the judge, it feels like what he did was he made orders that appeased Lively's concerns about third parties and trade secrets, but excluded them if they were directly a part of the allegations against the parties. That's not AEO protected. And so essentially, how effective is this AEO? When filing confidential materials with the court, the parties must get court approval before filing confidential documents under seal, meaning the judge is going to have final say about whether or not this is confidential or not. There is not an automatic sealing provision. Like you can't file a group of text messages and declare it sealed and confidential. No. Bullshit. The court has to prove it. And the judge will decide it case by case, piece by piece, text message for text message. He gets final say. If there is a party who disagrees with an AEO designation, they could negotiate with the other side. In other words, meet and confer. They could request court intervention. In other words, a contested hearing if you all can't come to an agreement. Confidential materials can only be used for the case, obviously, not for public relations battles. And the judge had a lot to say about that, and I'm going to get into that. leaking or unauthorized disclosure will result in contempt of court. Sure. Once the case is over, all confidential materials are to be returned to their rightful owners and or destroyed. So what's the impact on this case moving forward? Well, I mean, obviously, there's supposedly, I guess, by virtue that there is now an order, I don't see how it was any different from the model order, but for we now have less ambiguous definitions, I guess. There's going to be more control over media leaks. Blake's team has successfully, I guess, in some ways, limited Justin's access to highly personal and private materials, but only to the extent that they don't relate to direct allegations against him. So what did she really limit? Because Friedman came out and said, I'm not interested in the stuff they're trying to protect. And so then the judge is like, so then what's the big deal with protecting him then? And I feel like it's kind of what he did. The court did not allow broad restrictions. Everything case-by-case basis. Baldoni's still going to be able to access evidence if he thinks it's relevant. If they try to designate something as AEO and Friedman thinks that it's relevant to a cause of action against Justin, well, guess what? They're going to have a hearing, and it's likely not going to be protected. Obviously, we're setting clear categories for AEO designation. There's going to be future hearings, I'm assuming, on discovery. Third parties are presumably more protected. I don't see how they're any more protected than they were before. I don't think anybody's going out of their way to leak third-party information from anybody. But most importantly, there is not going to be this blanket protection for Blake. She has to disclose key evidence. She can't shield everything under the AEO rule. If her team misuses those designations, Baldoni could challenge it in court, and more importantly, she can get in trouble. So things are going to happen. The public is going to see most of the evidence, as we've been saying all along, at trial. And that's not really any different than we've been saying. I mean, look, they're doing discovery. There's going to be depositions. There's going to be some of this that gets out here and there. You're going to find out that, oh, they're going to depose Ryan Reynolds. Oh, they're going to depose Wolverine or whatever. And, people are going to make content about that. Judge made it clear that sealed evidence is going to become public at trial unless there's a reason not to make it. And, we've all seen trials in the public play out, and there are certain sections that the court does not allow the public access to. I think that we can expect major revelations about what's going on in this case, evidence-wise, if the case doesn't settle before trial. And really, that's it. This has been a concerted effort to try to keep a lot of this evidence from being litigated in the public, evaluated by the public, whatever. It's abundantly clear that the judge is not shielding anything that comes out in trial from the public, unless there's a really extreme reason to do that. So what does that mean? I think that it means that there is greater incentive for the parties to settle. For Lively, I think it just comes down to, look, she's getting hammered in the press. The more evidence that gets out that puts her out there as like this mean girl, bully personality that trying to erase Baldoni from the Hollywood landscape, I don't think that's very good for her career. For Justin, it doesn't seem like he is that hell-bent on keeping anything under wraps. At least I don't think. But to the extent that he wants to keep stuff out of the public, I guess that would be a motivation to settle. I just haven't heard Friedman's attorneys talk like that so far. So biggest takeaways, the TL too long didn't read version of this is some materials are going to stay hidden for now, but once trial hits, it's all coming out. All of it. All of it. With that being said, let me break into the reading of the judge's thing. Let me get off of that and share with you my PDF. That is F. Here it is. Okay. There we go. All right, so here we go. Let me just make this a little bit bigger. This is the memorandum in order. This is not the, well, there's a second thing. This is the actual protective order. This is document number 64. They just kind of outline it. I'm not going to read over all of that. It's just the specifics that they're going to refer to. This is basically the contract between the attorneys and the parties. That we are going to abide by the specific language in this order. This document, number 73, is explaining the judge's ruling from hearing the evidence on March 6th, and I will go over all of that with you. So let me get over to, all right, here it is. I got the right thing up? All right. So Blake Lively, Ryan Reynolds, Leslie Sloan, Vision PR, the moving parties have moved pursuant to Federal Rule of Civil Procedure 26C for entry of a protective order. There's more preamble stuff. Consent. The court held argument regarding the proposed protective order on March 6th. In this case, and in the related case, Jones v. Abel. Plaintiffs in Jones v. Abel are seeking entry of the moving party's proposed protective order, and defendants in Jones v. Abel object for the reasons stated by the Wayfarer parties in related case, docket number 2425 CV 779. For the following reasons, the moving party's motion for entry of a protective order is granted in part and denied in part. You win some and you lose some. The court will enter a protective order with a modified attorney's eyes only provision and certain other modified language. The court will enter the same protective order in the related case, Jones v. Abel, and otherwise this is going to cover both cases at the same time, as they're basically merging them into one as it is. Now, the Supreme Court has held that it is necessary for the trial court to have authority. You know what, let me do this or make myself crazy. Where did I leave off? The Supreme Court has held that it is necessary for the trial court to have the authority to issue protective orders conferred by Rule 26C because of the liberality of pretrial discovery permitted by 26B1. The federal rules of civil procedure provide for broad discovery of information for the purpose of assisting in the preparation and trial or the settlement of litigated disputes. While necessary, liberal discovery also allows extensive intrusion into the affairs of both litigants and third parties, and much of the information that surfaces during pretrial discovery may be unrelated or only tangentially related to the underlying cause of action. And just to give you an idea of how intrusive we're talking, when I just do boilerplate random financial discovery for the purposes of, I don't know, some financial proceeding, the things that I ask for is basically any financial documents for the entire relevant time period. And if we're talking about a 20-year marriage, that's going to be for 20 years because we got to get through the 4320 factors. We have to be able to determine to a reasonable degree of certainty what specifically their specific lifestyle was. And that will mean bank statements going back 20 years to the extent that we could get them. Any business contract they've ever entered into, any conversation or text messages or recorded voicemail that was related to a business contract, any and all business dealings, anytime that you've ever applied for a loan and represented your income anywhere, anytime, and it goes, list goes on and on and on. It is such a pain in the ass. It is so intrusive. You're going to feel uncomfortable when you're doing it. It doesn't matter what we're talking about. And so these rules that they're just saying, look, discovery is broad. They can ask for whatever they want. So long as it's relevant, you have room to object, but only under certain circumstances. So while necessary, liberal discovery also allows extensive intrusion into the affairs of both litigants and third parties. And much of the information that surfaces during pretrial discovery may be unrelated or only tangentially related to the underlying cause of action. Forgive me for skipping over this case law. If you guys want to look up the case law, here it is. But I'm not going to be reading those parts. This creates a significant potential for abuse. Litigants may use the discovery process to obtain incidentally or purposefully information that not only is irrelevant, but if publicly released, could be damaging to reputation and privacy. Federal Rule of Procedure 26C addresses this issue. I need my highlighter. Addresses the issue by allowing a court to grant a protective order to protect a party or person from annoyance, embarrassment, impression, or undue burden and expense. That's a pretty common discovery objection. Oftentimes it's overused and rarely works. The burden of showing good cause for the issuance of a protective order falls on the party seeking the order. A protective order may require that certain material obtained in discovery be kept confidential or disclosed only to attorneys. Notably, the latitude that the court and the parties have to protect information during pretrial discovery phase does not extend to court filings and to the trial phase after discovery has been winnowed down to that information which is truly necessary for the decision in a case. In other words, if stuff is privileged, if stuff is to be protected, if stuff is irrelevant, it is assumed that the discovery process is weeding all of that stuff out. So to the extent that the courts have an obligation to make these proceedings public, to stay within the good graces of the general public in fairness and trust, it's assumed that we've already gone through all of the evidence. If there was an objection to raise, you should have raised it then. If you haven't raised it by now, then you waived it and it's coming in. So we're very careful to conduct discovery carefully to make sure that we're not overly exposing the parties or third parties in any uncomfortable way. Then the public and the press have a qualified First Amendment right to attend judicial proceedings and to access certain judicial documents. The parties have agreed to the entry of a standard protective order, allowing any person producing discovery material to designate as confidential financial, business, and personal or intimate information, the disclosure of which would cause harm to the producing party and or to a third party to whom a duty of confidentiality is owed. Right? Where did I leave off? Totally lost my place. Oh, here we go. There is good cause for the entry of such an order. Each of the Lively and the Wayfarer parties have filed claims against the other. Jones, the owner of a public relations company, has filed claims against her former employee, Abel. The parties have leveled accusations of theft of trade secrets and the disclosure of confidential, sensitive information against one another. Discovery will inevitably involve some amount of sensitive business and personal information, the premature public disclosure of which could cause harm to the producing party or to a third party. Okay, so the parties part ways. However, on whether the protective order should include an attorney's eyes only provision, an AEO provision allows certain information produced in discovery to be shared only with lawyers for the party receiving discovery and not their clients. Citing case law, the moving parties argue that an AEO provision is appropriate because of the risk of sensitive details revealed in discovery will become weaponized by the parties in the media, chilling third parties from producing discovery and imposing an impermissible tax on the prosecution and defense of legal claims. The moving parties specifically note the potential harm to third parties who could have private and sensitive information spread through the press as a byproduct of this litigation. The Wayfarer parties respond that Lively has already disclosed personal sensitive information related to her alleged harassment. They suggest that there is no need to presumptively designate material AEO at this time, and any need for material to be designated AEO can be determined as it arises. The moving parties have shown good cause for a limited AEO provision and have shown that entering such a provision now is critical to the just and speedy, if not necessarily inexpensive, determination of the case. They cite Federal Rule of Civil Procedure 1, in particular the disclosure to the parties of certain information that will invariably be exchanged during discovery, but which may not be necessary to the prosecution and defense of the case. Presents an incremental risk of annoyance, embarrassment, or oppression, etc., that cannot be effectively controlled simply by the court's model protective order. Under FRCP 26C case law, the courts Model protective order permits disclosure of information exchange and discovery to the parties and to fact and expert witnesses who sign an agreement that they will abide by the terms of that protective order and who agree to subject themselves to the jurisdiction of the court for purposes of enforcing the protective order. The willful violation of any term of the protective order is punishable by sanctions, including contempt of court. That provision is effective in the run-of-the-mill case in which the court can punish the violator with financial sanctions or order the return of confidential material, but they kind of pointed out that I don't think they give a shit about sanctions, Your Honor. They have unlimited, they have $100 million to spend on this lawsuit. In an ordinary case, the party's primary interest is in the resolution of the lawsuit. The risk of disclosure is low, and if disclosure is made, it may be apparent. Moreover, the cost of the financial and other sanctions that the court might impose is greater and the benefit obtained than the benefit obtained from disclosure. The court's model protective order is not sufficient for the needs of these cases. These cases involve both business competitors and allegations of sexual harm. Discovery will necessarily include confidential and sensitive business and personal information. The risk of disclosure is great. Both the moving parties and the Wayfarer parties have accused opposing parties of providing private, sensitive, or confidential information to the media for their own business and personal advantage in ways that cannot be easily traced. Several individuals and corporations on each side are in the business of public relations or media and have easy access to the press. The details of this case have been closely followed in the media, and each side has accused the other of litigating this case via the media. And where confidential information is not disclosed to the media, it may be spread by gossip and innuendo to those in the tight artistic community in a position to do harm to one or the other of the parties, but in a manner that might not be readily and immediately detected. In the context of this case, there is good cause to allow several categories of information to be marked AEO. He cites Stern v. Cosby. The disclosure of trade secret information in the form of business and marketing plans for projects other than it ends with us to a competitor who would have the ability to use that information to further its own business interests poses an incremental risk, I think they meant risk, of inevitable disclosure and use that is different from the risk presented when the information is disclosed to a lawyer representing the business competitor. And if you don't think that that's a thing, look, I've had cases where business secrets have been disclosed to other attorneys, where all of a sudden the party on the other side is doing things that affect the business that's not readily detectable. If it happens with private folks, it sure as shit is going to be able to happen with celebrities. Even if the competitor does not seek to misuse the information, it may be impossible to forget a client list or secret formula after having seen it. If you've ever seen Marco Pierre White chop an onion, it's really hard to unlearn that. It's masterful. He cuts up the onion like so fine, like it just literally just melts into the pan, melts into the sauce. It is, if you're into cooking stuff, something that you're not apt to forget. It is very difficult for the human mind to compartmentalize and selectively suppress information once learned, no matter how well-intentioned the effort may be to do so. The same protection is justified with respect to business plans for and of non-party clients, confidential strategies, and details about non-public creative projects. An author or creator of a creative product, including some of the parties to this case, may find it difficult in generating their own creative product to set aside information that they learn about the confidential works and progress of another party. Therefore, AEO that bitch. The medical records of parties or third parties may also properly be marked AEO, albeit for somewhat different reasons. There is not the same risk that such information wittingly or unwittingly being misappropriated by another party for their own personal benefit. Medical records are information of the most intimate kind, and leaks of parties or third parties' medical information would be highly likely to cause severe privacy injury. It may become necessary for such information to be disclosed to a party at some stage and depending on its contents, but given the accusations that the party have made against one another and the challenges that the court would have in enforcing the protective order against persons other than the lawyer, an AEO designation is appropriate. And that doesn't surprise me not one bit. Although I can see a world where Blake Lively's medical records may become relevant to this case, insofar as Friedman is going to argue that her perceptions of harassment have been sullied by her diagnoses of some kind of mental malady. Who knows? Major depressive disorder, bipolar disorder, ADHD. Perhaps there's like trauma in her background that made her overly sensitive to the point where she's making allegations of sexual harassment that no reasonable person would ever co-sign on, which is kind of the requirement of her cause of action. Even so, it's not that they're not going to be able to get that information. It's just that they can't show it to Lively. But to the extent that it becomes relevant and part of the trial, then it's going to be out there for the entire public to see anyway, which is kind of the judge's point. So AEO, but to an extent, which is why I was saying that, all right, good for them. They have an AEO provision in there now, but what is it really protecting? All we're really after is relevant evidence. If it gets into trial, chances are really high that it's going to get out anyway. Did I read this part already? Yeah. Another AEO category in the protective order is security measures taken by parties or third parties. Friedman already said he doesn't give a shit about that. The Wayfarer parties have suggested that security measures are not relevant to this proceeding, but they have not raised objections to such information being kept attorney's eyes only if it is disclosed. If such information is disclosed, it is highly confidential information with a significant potential for harm, and it may be properly designated AEO. The most challenging AEO category is highly personal and intimate information about third parties and highly personal and intimate information about parties other than information directly relevant to the truth or falsity of any allegation in the complaints in this case. This case involves allegations of sexual harassment and retaliation of such harassment. Lively has asserted claims for damages in the form of emotional distress. Some information of a personal and intimate nature regarding the parties will inevitably have to be shared with persons other than the attorneys, i.e., the pregnancy video of Heath that was disclosed to Lively. How thrilled do you think Jamie Heath's wife is to know that that highly personal video that was shared in confidence with Blake Lively has now been published to the entirety of the world? Maybe she's thrilled, I don't know, but maybe she's a little bit offended at the invasion of privacy. The parties who are making the accusations or who are the subject of the accusations have a right to participate in the prosecution and defense of the claims. The attorneys have a need to consult with their clients. At the same time, however, it is in the nature of discovery that the net will be cast wide and that each side will be forced to disclose to the other information of a sensitive, personal, and intimate nature that is not necessary or even relevant to the prosecution or defense of the claims. Just because you say it's not relevant doesn't mean that I don't think that it's relevant. Attorneys are smart. Attorneys are supposed to be able to sit with the evidence and decide what evidence belongs to what specific element in specific causes of action. If you don't think that you don't want your private, intimate text messages getting out in the public, fine, but I still need to see it to make sure that it doesn't somehow shed light into the allegations that you made. And even more so, in the off chance it might be exculpatory to my client, I need to review that. Otherwise, I'm never going to know. So look, you could say it's private all you want, but the nature of the allegations lend itself that you're going to have to turn it over anyway. It's not all getting published, but if it becomes an exhibit at trial, it sure as shit is going to get published. And that's what he's talking about right here. The point is even more apparent with respect to non-parties. These people haven't signed up for a lawsuit, but by virtue of the Rule 45 subpoena power, they will inevitably be brought into it. And their personal information, which may be contained in the documents to be discovered, may well be the least centrally relevant to the determination of this action. In order to facilitate the flow of discovery, an AEO provision is appropriate for that category of information. Before the parties make an AEO designation, the protective order places on them the burden of determining that the information is not directly relevant to an allegation in the pleadings. In other words, if they want to protect something, Friedman thinks it's relevant, they don't think that it's relevant, it's on the parties to determine that for themselves, then there's going to be a hearing and then the judge is going to decide. For the non-parties, no such burden is appropriate. They are entitled to designate all information in this category as attorney's eyes only, placing the burden to demonstrate the importance of the information for the prosecution or the defense of a claim on the counsel seeking to disclose the information to their client. And that's fair. The attorneys are still going to get the information. But it's true. It's the probability that third-party info is somehow going to become relevant to this case. They're going to have to make the argument to the judge, and I don't think that there's anything wrong with that, and it's fine. I don't disagree with this order so far at all. The court is cognizant of the right of the parties to assist counsel in the litigation. The moving party's proposed AEO provision is not limited to the categories set out above and would allow any material to be marked AEO if it is of such a highly confidential and personal, sensitive, or proprietary nature that the revelation of such is likely to cause a competitive, business, commercial, financial, or privacy injury. The language likely to cause competitive, business, commercial, financial, or privacy injury is very broad. It mirrors that in the court's foreign protective order, which does not contain an AEO provision. In the context of this case, almost any information provided in discovery could be labeled as likely to cause a commercial or privacy injury. The court has narrowed the provision to stated that information may be marked AEO only if its disclosure is highly likely to cause a significant business, commercial, financial, or privacy injury. Moreover, at this time, such information should only be marked AEO if it fits into one of the categories enumerated in the protective order, which is document number 74 that I showed you earlier. If a disclosing party believes information which does not fit into any such category is of such a highly confidential and personal, sensitive, or proprietary nature that the revelation of such is highly likely to cause a significant competitive, business, commercial, financial, or privacy injury, and therefore an AEO designation is justified, such party may apply to the court for modification of the protective order consistent with the principles set forth in this opinion. We haven't got to the scathing part of it yet, but it's coming. The Wayfarer parties argue that the entry of an AEO provision is premature. Given that discovery has not commenced, they suggest that a conversation regarding AEO designation would be more appropriate once information arises that a party wants to designate AEO. They express concerns that AEO provision will be overused and that the party opposing such designation will be required to consistently bear the burden of having information de-designated instead of the party seeking designation being required to support it in the first instance. To the contrary, entry of an attorney's eyes only provision at this time is intended to make discovery more efficient and prevent repeated disputes over proper designation of discovery material. Although the Wayfarer parties suggest that the conversation should occur later, they have not stated any reason that security measures, medical records, or trade secrets would not be properly marked attorney's eyes only. And I did note that in Friedman's argument, he was not really pushing back on this idea that some of this stuff is highly should be protected. Matter of fact, he said, look, Your Honor, I have no intention of leaking stuff. We don't need, his point was, I don't need an attorney eyes only provision to follow the court's orders. I'm just going to follow them. And so then the danger in arguing that way is the judge is like, so then what's the big fucking deal? Then I'm just going to put it in. And no harm, no foul then, right? That was what he said. Oliver Girl with $2 says, counts for dots. The lady Lauren gots to go. She be right back. What are you talking about, Oliver? Oh, I'm not sure how to interpret that. Are you talking about Lauren Nighty? The lady Lauren gots to go? I'm not sure. She be right back. Counselor. Oh, counselor. Counselor. I'm sorry. I get it now. I get it. I do the same thing on my, when I do my, I typo all the time in my text messages. Redondo Beach, how you doing, young lady? Prime viewing while I sit in the IV chair. Hey, wishing you well. And I hope you feel better soon. I appreciate you listening to me anyway as you sit in your IV chair. Let me continue with this document. All right, so he's stating reasoning. Okay, so clarifying now that such information may be designated attorney's eyes only allows the disclosing party to provide it to the attorneys efficiently in response to discovery requests. Subsequently, if there is an issue with a particular designation, the receiving party may raise that with the court. If the party disclosing must confer with the opposing party and possibly come to the court each time AEO treatment is desired, that's going to cause delay. In other words, the judge is saying, if you don't give a shit about what they're trying to designate, then you can't make the argument to me that you're going to be the one with a greater burden. So we're just going to flip it, is what he's saying. He's using Friedman's argument against him. All right, the disclosing party will not be able to disclose the information, even to the requesting attorneys, until the request is resolved. If AEO protection is generally appropriate for a certain type of information, it does not make sense to require a new discussion every time a party wishes to designate such information attorney's eyes only. It makes more sense for the receiving party to ask for de-designation in the rarer cases where the AEO designation is appropriate, and I agree with that. The court has made several other changes to the language of the proposed protective order in the interest of precision and clarity. Most of these changes were discussed in oral arguments. The motion for the entry of the moving party's proposed protective order is granted in part and denied in part, and then we get into appendix stuff. This is the protective order. All right. And he's just outlining specifics. Y'all want me to go over this in detail? I mean, I might as well, huh? I already kind of have it open. Screw it, do it. I'll do it. All right. This attachment. All right. So whereas all of the parties to this action, this is the actual order. Whereas the parties acknowledge, whereas the parties further acknowledge, whereas in light of, it is hereby ordered that any person subject to this protective order, including without limitation, the parties to this action, their representatives, agents, experts, consultants, all third parties providing discovery in this action, and all other interested persons with actual or constructive notice of this protective order shall adhere to the following terms. Any person subject to this protective order who receives from any person subject to this protective order any discovery material that is designated as confidential or attorney's eyes only pursuant to the terms of this PO shall not disclose such confidential discovery material to anyone except as expressly permitted hereunder. The designation attorney's eyes only shall only be utilized for confidential discovery material. Again, they talk about trade secrets. I'm not going to read it for word. I'm just not. Security measures, I think we've covered it. Medical information, highly personal, intimate information. The protections conferred by this order cover not only confidential and attorney eyes only, but also information copied or extracted therefrom. And we're getting into that. The person producing any discovery material may designate as confidential or AEO only such portion of such non-public material of the public. And then they go into other provisions that we've already discussed. With respect to deposition transcripts, I thought this was interesting. A producing person or that person's counsel may designate such portion as confidential or attorney's eyes only, either by indicating on the record during the deposition that a question calls for CDI, in which case the reporter will bind the transcript of the designated testimony consisting of question and answer in a separate volume and mark it as confidential information governed by protective order or attorney's eyes only information governed by protective order. It's really not that big of a deal. It's more of a pain in the ass for the person preparing the transcript. You got to notify the reporter and all counsel of record in writing within 30 days after depo. During the 30-day period following the conclusion of deposition, the entire deposition will be treated as if it's designated confidential or attorney's eyes only. What does that mean? Whoever's getting deposed, you're not going to know about it or the contents of that deposition for 30 days, and they're not going to talk about it either. I would think they wouldn't talk about it. If I were to depose Taylor Swift, I'm not running to the press as like, oh yeah, I just had this Taylor Swift deposition, and we talked about A, B, C, D, E, and F. Because I think that would probably be in violation of some things. If they treat it as confidential, you should just pretend that it doesn't even exist. Unlike some other attorneys that we have covered on this show. If at any time prior to the trial of this action, a producing person realizes that some portion of discovery material that she, he, or it had previously produced without limitation should be designated as confidential or attorney's eyes only, she, he, or it may so designate by so apprising all prior recipients of the discovery material in writing, and thereafter such designated portions of the discovery material will thereafter be deemed to be and treated as such under the terms of this protective order. No person subject to the PO other than the producing person shall disclose any of the discovery material. Fine, counsel, outside vendors. All right, so with respect to discovery material designated as attorney's eyes only, such material shall only be disclosed to those persons identified in paragraphs 6B, C, D, E, G, H, and I, but shall not be disclosed to the parties. In other words, attorneys all around, expert witnesses, and such. Prior to the disclosure of any confidential discovery material to any person referred to in subparagraph 60, F, and G, such person shall be provided by counsel with a copy of this protective order and shall sign a non-disclosure agreement in the form annexed as an exhibit hereto, stating that the person has read this PO and agrees to be bound by its terms. So no fair saying that I didn't know. This is just more warnings and admonitions. A party may be requested to produce discovery material that is subject to contractual obligations within 2 business days, and it's not very interesting. All of this stuff is just more boilerplate stuff. This is the acknowledgement form that they're talking about. So once you sign it, then you can no longer say that you've been misinformed. All right. Let me just check something real quick. All right. So my final takeaways from this is that the judge is kind of acknowledging that there's an issue with the way that PR has been conducted in this case. He's issued prior admonitions to, specifically to Friedman when they went through that 168-page timeline, if you guys would recall. But he's like, look, both of you guys are accusing you guys of shady things. He flat out acknowledges that this case is not normal insofar as it is a high-profile case where it really appears readily apparent to me that both of you guys are trying to litigate this case in public. And then he used that as the basis to craft these extra protections. He stated that the risk of sensitive information being leaked or manipulated, it's greater than in a typical case. And if you recall, on page 6, he says, both the moving parties and the Wayfarer parties have accused opposing parties of providing private, sensitive, or confidential information to the media for their own business and personal advantage in ways that can't be easily traced. In other words, he knows that there's probably a lot of bullshit going on. And he's kind of putting both sides on notice that, look, I mean, he put him on notice back in January, like January 30th, I think it was. But now he's kind of doing it again. I got my eye on you guys. And were it not for both of you accusing the other of leaking stuff to the press and fundamentally actually leaking stuff to the press and purposely trying to litigate these things in public, maybe it wouldn't be a need for an attorney's eyes only provision. But I can't trust you folks, and so I'm going to do it anyway. He said there were several individuals and corporations on each side that are in the business of public relations or media and have easy access to the press. So he's basically just calling them both out. Stop trying to, well, he didn't say stop trying to weaponize the media. He just says, I know you guys are weaponizing the media. And because of that, neither one of you can be trusted. Lively's team straight out said that Friedman can't be trusted. Friedman said, I take offense to that. They are the ones that can't be trusted. And then the whole thing about, look, I'm going to view these as allegations, Mr. Friedman. And then Friedman's like, but they're not allegations, Your Honor. They said word for word. And then the judge was like, I'm going to stop you right there. You're not giving testimony right now. I did not put you under oath. I'm going to treat these as allegations. And he kind of yells at him in the hearing. Judge Liman acknowledges, I think, that leaks and gossip have been weaponized. They can continue to be used as a weapon in this case, not just because it's a high-profile case, but because, look, it might just be the fact, and he's sensitive to this idea that there might be trade secret stuff that gets released that is unique in the entertainment sphere, that people could just run with it and use it to their own devices. It could affect reputations and careers. He recognizes the power of innuendo in Hollywood, where simply being associated with a case or a scandal could get you canceled, for example. I thought it was interesting when he said, in the context of this case, there is good cause to allow several categories of information to be marked attorney's eyes only. Where confidential information is not disclosed to the media, it may be spread by gossip and innuendo to those in the tight artistic community in a position to do harm. He wrote it artfully, but what that really represented to me is a strong admonition to both sides that the way information has been spread in this case, the way that it spreads in Hollywood, oftentimes without proof, and justifying or trying to litigate this case with they're doing, he's justified in issuing this overly protective AEO provision in ways that he wouldn't normally because he just doesn't trust either side. He talked about these past cases that have been used as a media for media spectacle when other cases have attempted to be litigated in the public. He sees this case falling in line with those cases. And on page 6, he says, discovery is not intended to be a vehicle for generated content for broadcast and other media. And I guess that would include YouTube. Much of the information that surfaces during pretrial discovery may be unrelated or only tangentially related to the underlying cause of the case. And insofar as it's not related to the case and it gets out anyway, that could be damaging, privacy damages and other stuff like that. So bottom line is, Judge Liman was not born yesterday. He knows what's going on. He knows how the parties want to litigate this case. He's got their eyes on everybody. And to his extreme credit, he's doing it incredibly artfully, the way that he's issued this order. And you might not read that language as strong admonitions, but if I'm reading that as counsel for either side, I would be very leery of continuing to litigate this case in the media the way that it's been. And if you notice, I feel like both sides have kind of pulled back in their involvement with TMZ and other media outlets. I haven't really seen many interviews related from the attorneys anyway about this case, not in the same way that it was earlier. I mean, maybe here and there, but not like it was back in January. So Judge Liman is aware. I think the attorneys are on notice. I kind of felt like this is the way that it was going to go a couple of days ago when the judge seemed to be interested in specific categories. And then he was asking Friedman, so then what's the harm? If you don't think it's a big deal, then what's the harm? And then the judge is like, or then Friedman's like, well, it's not that there's a harm. It's just that I don't feel like I need to come to court every time I need to de-designate something. They're the ones that want the designation. They should be very specific about it. And also, fuck all of that. I'm not here to violate orders, Your Honor. I intend to follow your order. And so the judge hears that and is like, oh, good. Well, then I'm just going to issue the AEO if it's not that big of a deal. And that's how it ended. But at the same time, Lively is not, there was not blanket coverage for her. All of her medicals are not protected. By virtue of her allegations, a lot of the stuff that she doesn't want to get out there is going to get out if it becomes evidence at trial. And you ask me, so what's the incentive to settle? Because they don't want this shit to get out because it's already been enough damage. I don't know how damaged she's been. I honestly don't know. I don't know what her career looks like after this. My only point of reference would be Depp v. Heard. One of those two is thriving with job opportunities, and the other, I haven't really heard from her since. Like, it's gotten to the point where I think I might like try to shoot her a request for an interview to talk about her experiences on the Tilted Lawyer podcast because it's going that bad for that lady. I actually think she moved out of country and is like she's probably doing fine. Obviously, she's never going to come on my show. I'm just saying. How you doing, Renata? Good to see you in the chat. Renata is the one person that I've been able to identify that watches my show that is, I don't want to say she's Team Lively, but she's sympathetic and she's being very discerning in what comes out and very careful to and objective with the evidence. Renata says, I read that as an admonition also. I don't know why supporters are so emotional and upset. This doesn't mean evidence will not be produced. Just they won't leverage it to the media. Yeah, evidence is still coming in. Look, they're still going to litigate the case. Just because you don't see it on a YouTube stream or in media somewhere on TMZ doesn't mean that it doesn't exist. If it's good enough to be a trial exhibit, I promise you, you're going to know about it. What you're not going to get is like the 5,000 pages of discovery that's being produced. You're going to probably get like, a couple hundred pages of that to the extent that it's relevant. Depositions are still going to be publicized according to what I can tell. There's just a 30-day wait to publish it. Let's just treat it as confidential. We're going to give every deposed party an opportunity to identify in the transcripts anything that should be attorney's eyes only. There's specific instructions on how to treat that at deposition. Like you ask questions like, objection, I believe this is AEO. Let's go off the record, and then they'll make their do what they got to do, and then treat it as two separate transcripts. And so you're still going to get all the information. Nobody has won anything here, evidentiary. They've just outlined the rules about how they're going to produce evidence. And I guess if there's any losers, I guess it's people that are wanting every bit of discovery instantly as soon as it comes out, hot off the presses. But I don't recall any case ever being that way. So there's nothing lost here. There's no surprises here. There's no tricks. This is all pretty common fare. The AEO provisions were, I feel like, designated by the judge because Friedman specifically said he doesn't give a shit about what they're trying to protect. And then the judge is like, great, so then I'm going to order it. And if you disagree with any stuff, then I guess you'll come to court and we'll fix it. As opposed to the other way around. So that's where we're at with that. Oliver Gruhl says, judge needs the proverbial should her get off the pot? Admonish original leaker to Medua, a.k.a. Lively, Medusa, and deny protection until Lively party plays fair with Baldoni team. Rainbow Pickle, happy pickles then. She says, happy Omar, happy pickle. How about that? All right, folks, that's all I got for you on today's order. I might stream later tonight. I'm not sure yet, but I'm definitely streaming tomorrow. I have my normal daily podcast that I'm going to be doing, and we're also going to be doing some family law after dark. Maybe we might be able to get a wayward moose in there. Maybe a wayward schnitzel ninja. Maybe Brad might wander in. You never know who's going to show up to Flad. It's going to be at its regular time around 7:30 Eastern time, 4:30 Pacific. Other than that, I love you guys, and I hope you have a wonderful rest of the day. I will see you all on the other side. Love you all. Bye-bye.